Thank you.
Thank you, Madam Chair. I'm Kent Scheidegger with the Criminal Justice Legal Foundation. I've been representing the interests of victims of crime for almost 30 years now, and much of that has involved capital cases. California capital appeals take longer than is the norm in many other states. We've known for many years how to fix that. Legislative efforts have been unsuccessful, so now we must turn to the initiative. The main focus I want to talk about is the habeas corpus cases, since that's been the subject of several questions. Capital habeas corpus in California is routinely filed in the state Supreme Court, which generally decides the case without referring the case to a trial court. No other state, to my knowledge, does that. Habeas corpus cases are mostly factual. Their purpose is to consider factual allegations outside of the trial record. They rarely involve unresolved questions of law, and that's the sort of thing that belongs in the trial court. Other states either begin them there or they routinely refer them there. Under this initiative, the habeas corpus petition would be normally filed in the trial court and normally assigned to the original trial judge. That's what the federal system has been since 1948, a system widely copied in other states. The Supreme Court of the United States has noted that the trial judge is the one in the better position to judge such claims as ineffective assistance of counsel, which is one of the most common claims in these cases. It is far more efficient for a single judge who is already intimately familiar with the case to review these voluminous petitions rather than 7 justices cold to the case, taking it from scratch. It's not unusual for these petitions to sit in the California Supreme Court for years. The trial judge's decision would be reviewable by the Court of Appeal, and as the LAO mentioned, that is a new layer, but it's still more efficient overall because when a court is reviewing the decision of another court, when it already has a thorough opinion disposing of all the claims, you can pretty easily pick out the 1 or 2 claims that may have a real substantial basis and more easily dispose of the remainder. So I think that even though there is an additional layer, it is still a far more efficient system, and that's why practically every other jurisdiction has it. The second issue is the so-called successive habeas corpus, a second or third or fourth habeas corpus petition filed by somebody who has already had one petition reviewed and denied. In the case of In re Reno, the California Supreme Court described the abuse that goes on routinely in these successive petitions. Petitions of many hundreds of pages, many hundreds of claims, most or all of which are clearly without merit. These are routinely filed. They serve no purpose. In most cases, they are delay and expense with nothing to show for it. This initiative would make a major reform with a rule against successive petitions, and unlike the current vague exceptions, it would have a clear, simple exception. We would continue to allow successive petitions for claims of actual innocence or actual ineligibility for the penalty, such as, for example, intellectual disability. Such claims are rare. We have not had anyone found actually innocent in California. We have had some found ineligible when the Supreme Court retroactively changed the rules of eligibility, but that was a one-time event. So we would preserve successive petitions for the claims of actual innocence. That's an important safeguard. The question has been raised whether a limit on successive petitions is constitutional, whether it might violate the suspension clause. The U.S. Supreme Court answered that definitively when a similar claim was raised against a reform passed by Congress in the case of Felker versus Turpin in 1996. It's important to remember that most capital cases involve no question of innocence. The bulk of litigation involves questions irrelevant to innocence. So we would preserve successive petitions for those that do, focus on innocence, and if we do that, if there is a case of actual innocence, we're more likely to discover it sooner. This is a carefully drafted and well thought out proposal. It would address delays and reduce costs without loss of ability to correct actual miscarriages of justice. Thank you.